panel is going to be Mick Pappas. Mick, thank you for your patience. I've seen you popping in there. And I know that you actually got work today. So thank you for taking the time to come with us today.
Thank you, Your Honor. I appreciate the opportunity to be here. Thank you to Chairman Bizzaro and everybody else who has taken the time to come here and share their experience, their thoughts, their expertise. It's a pleasure to be here with so many esteemed stakeholders and to address an issue of such public importance, the elimination of cash bail in Pennsylvania. My name is Mikhail Pappas, and I serve the public as a magisterial district judge representing 8 neighborhoods in the east end of the city of Pittsburgh. As part of my position, I preside as an issuing authority in bail matters arising from throughout Allegheny County. While I'm a proud member of the Special Court Judges Association of Pennsylvania, and I'm an active as a leader and member of a number of community-based organizations in the southwestern Pennsylvania region, today I am here on behalf of myself, and consistent with the ethical rules to which I am faithfully bound, on behalf of measures to improve the law, the legal system, and the administration of justice in Pennsylvania. I am not here to promote or endorse any one particular legislative proposal or another. I am here to share the insights that I've acquired as a practicing attorney and judge who has presided in well over 1,000 bail matters. My message today is simple. I believe we can safely eliminate cash bail in Pennsylvania. I believe we can best do this not by limiting judicial discretion or binding judges to bail schedules and risk assessment algorithms. As William O. Douglas, a justice of the United States Supreme Court for 36 years, once said, "The law is not a series of calculating machines where definitions and answers come tumbling out when the right levers are pulled. Rather, I believe we can safely eliminate cash bail by working together with the judiciary system stakeholders and community stakeholders to expand access to more effective restorative alternatives." Some would say that a police encounter presents the first opportunity for diversion from the criminal justice system. Some would say that diversion begins even sooner than this with prevention through access to affordable housing, high quality public education, equal opportunities to earn a living wage, and universal health care. Even if we assume that both of these propositions are true, when a person has been accused of a crime, arrested and detained, temporarily deprived of their liberty, while remaining cloaked in the presumption of innocence, there is something awesomely powerful, purposeful, and vital to our democracy about what happens next. They are taken before a judge. They are taken before a disinterested arbiter of justice and an independent fact finder who decides not from the clamor of the corner, but from the sanctity of a calm courtroom. It is paramount to preserve the integrity of that moment by ensuring that judges have an abundance of diversionary supports and options available. The judge is tasked with striking a delicate balance, protecting the fundamental right of the accused to pretrial release, while at the same time protecting the community and alleged victims from risk of harm. This requires that the judge make a highly fact-sensitive inquiry into the individual characteristics of the accused and the circumstances surrounding their arrest. And it requires that upon completion of that inquiry, the judge have the means to craft conditions that are narrowly tailored for each individual case. Now, one can imagine how a rudimentary tool like cash bail would make this an exceedingly challenging task. For instance, no matter how refined an inquiry the judge undertake, it is most likely going to be the case that conditioning a person's release on their payment of a sum of money will guarantee little more than prolonged incarceration. This is because about 80% of the people who are accused of a crime are poor enough to qualify for the services of a public defender, which means that arguably 80% of people who are accused of a crime do not have the ability to pay any amount in exchange for their release. As I'm sure others will point out today and already have, this raises serious due process, equal protection, and ultimately public safety concerns. I ask myself, as a person and official with a responsibility to promote confidence in our judicial system, what is the message that we as a system send to the public when we rely on such undiscerning and potentially exploitive devices? Are we saying that even if we see you, we cannot reach you? Are we saying that even though we must protect you, we're still trying to figure out how? We all know that the public is ready for us to do better. From in Allegheny County, East Liberty to Ross Township, from Swissvale to South Fayette, and everywhere in between, the vast majority of people agree that access to justice through our courts should not depend on what's in your wallet, purse, or bank account. I would briefly conclude with an example. It is not uncommon for a person with a disability like autism spectrum disorder, or a person suffering from a drug addiction, or a person with a chronic mental illness to appear in arraignment court for a bail hearing. Oftentimes when this happens, it would seem that but for some combination of this person's present circumstances and their condition, they would be eligible for pretrial release. But here's the thing. It is not their condition. It is ours. More specifically, it is the conditions of release that we do not yet have, that we have not yet developed, but that would be narrowly tailored to fit the individual circumstances of such vulnerable persons and ensure their immediate safe release from incarceration. That, to me, is our challenge. We need to stop blaming people for things that are beyond their control and start taking responsibility for the things that are entrusted by the public to be within ours, as leaders, as system stakeholders, and as community stakeholders. We can safely eliminate cash bail in Pennsylvania by ensuring that judges have an abundance of diversionary supports and options available at that critical moment when conditions of bail initially are set. Thank you.